Hey everyone, welcome to our webinar today, Privacy Watch update from April 2023. I am just going to give about 30 seconds or so for people to get in, and we'll go ahead and get started. All right, well, as people are trickling in, I can go ahead and do a real quick introduction. My name is Nick Whisler. I'm sure I know many of you, but for those who don't, I'm a partner here at McMurray & Schuster. My co-panelist today is Josh Stevens, one of my partners here at the firm. And Josh and I work together closely on a lot of privacy matters for clients of all different sizes and all different industries. So today, we're just going to give an update on a number of different things. Before we get started on that, though, a quick disclaimer. Today's information is just kind of intended to be general information, not intended to be legal advice, standard attorney disclaimer. I'm sure most of you are familiar with that. So with that, moving quickly to today's agenda, Josh is going to give us an update on what's going on with the forthcoming laws, the state legislation. We've seen a lot of activity recently, so he's going to give us an update on that. Colorado had issued final privacy regulations that go into effect on July 1st of this year. So I will go through some of the key provisions of that. And then we will transition to a CPRA update in California. So what's going on there, some of the implementation issues that businesses are experiencing. And last, we're going to round out with update on privacy enforcement. So a lot of stuff to cover today, and we'll just go ahead and dive right in. So Josh, why don't you get us started?
Sure. Thanks, Nick. And thank you all for joining. Before we get into the states, though, I think the question that you're probably wondering is, what about the federal government? And the reason we're not really talking about them is because there's really not much going on, if we're being honest. The American Data Privacy Protection Act, and whatever iteration it's in now, is still languishing. The issue still seems to be around private right of action. One group wants it, one group doesn't, and then also around preemption, whether the federal law should preempt the state laws or just act as a floor. And again, one side wants it, one side doesn't, and they're pretty well dug in. Especially the California delegation in the House seems to be very much in the just a floor camp. And so until there's some movement on those two positions, I think it's going to be difficult to get any federal bill through. And so that's why all the action's happening at the state level. And the map that you see here on the screen is one that IAPP, the International Association of Privacy Professionals, puts out. This is actually a little bit out of date now, and we'll get into that on the next slide. But as you can see here, the number of states considering privacy legislation this year was fairly significant. Several of the bills have died, mostly as the result of sessions coming to a close. The states in green are the lighter green, are the states that already have comprehensive privacy legislation that is passed. And I do want to note, we're talking today about these comprehensive general privacy bills. We're not talking about sector-specific bills like financial or HIPAA type laws. For example, there's a bill in Washington that recently passed specifically around health data. We're not going to get into that. We're really talking these general bills. But as you can see, there are 6 states lit up here in bright green. California and Virginia are already in effect. Colorado and Connecticut come into effect on July 1st, Utah on December 31st, and Iowa on July 1st of 2020, I always forget Iowa's because it's so new. January 1st of 2025 is when Iowa will come into effect. So as I mentioned, this map is already a touch out of date. And so let's talk about what's happened, honestly, just in the last few days. We have now, as I mentioned, Iowa has passed and signed their comprehensive privacy bill that comes into effect January 1st of 2025. 3 states have passed comprehensive privacy bills. They have not been signed by their governors yet, but we fully expect that to happen. Those are Indiana, which will come into effect January 1, 2026, Montana, which comes into effect October 1st, 2024, and Tennessee, which comes into effect July 1st of 2024. 3 other states are close. Hawaii, the bill has passed the state Senate. It's sitting in the House. New Hampshire, same situation. And Oklahoma is essentially the reverse. It's passed the state House. It's sitting in the Senate. For those of you who watch our webinars frequently, you probably heard me last year at one point make a prediction that we would get 2 to 3 bills this year. I was not expecting 4 for sure, and maybe 7 or 8 on the outside. So I think we are seeing the states really pick up the mantle that the federal government hasn't been filling. And the one good thing, though, about most of these bills is that they're fairly similar. They are modeled generally on that Virginia, Colorado model that, for those of you who have been implementing these privacy regulations, you're familiar with. It's a bit different than California, but it's often been recognized as a more business-friendly, perhaps easier to comply with model. Although I could debate that, particularly with Colorado and some of the regulations that Nick will get into here in a little bit. Mallory, if you wouldn't mind moving to the next slide. So as I mentioned, they generally are following this model with similar size thresholds, although there is some variability. So if you recall that Colorado-Virginia model, it's typically these laws apply if you process personal data of consumers in the state and you have 100,000 state, specific state consumers' data, or 25,000, and you derive a certain percentage of your revenue from personal data sales. Sometimes that's 25% or 50%. It varies from state to state. And these types of thresholds are what we're seeing in most of these bills. Montana, for example, is a slight exception. There are 50,000 consumers, so there's a lower threshold there. Given their population, that probably makes sense to have a somewhat lower threshold. On the screen, I've also mentioned Oklahoma, which has differed from this model quite a bit in that you can trigger it 3 ways. Either 15 million in gross annual revenue, which is similar to the California model, which had 25 million as a threshold, or you have 50,000 consumers, or you derive at least 25% of your gross revenue from data sales. And there, what's interesting is it's not a number of consumers plus a percentage of sales trigger. The percentage of sales alone can trigger. Now, the Oklahoma bill is still pending in the legislature. It hasn't passed yet, but that's an example of a little bit of variation that we're seeing.
Yeah, I think that's important, Josh, because as you mentioned, California's has a revenue threshold that by itself will trigger the applicability of the requirements. Those other states generally do not. So Oklahoma could be the second, and it's definitely something to pay attention to for businesses that maybe are of a certain size, but don't do a lot of business and don't collect a lot of personal data in certain states.
Absolutely. One of the good pieces, I guess, if you're a business looking to whether you need to comply with these or not, is a lot of them do have really nice exemptions for entities that are governed by HIPAA or GLBA. And Montana, Indiana, and normally I would have this completely memorized, but as I mentioned, these bills just passed. Tennessee all have the entity-based exemption, and a number of the other states that are considering these bills also have an entity-based exemption. So what's important about this is, say you are a financial institution and you collect both information that's governed by GLBA and information that is not governed by GLBA. Under a model like the California model, which has a data-based exemption, the GLBA covered data is exempt. But under a model that's an entity-based, all of the data that you have is exempt because of you being a financial institution governed by GLBA. So that is a nice exemption to have if you're a financial institution or if you're a covered entity under HIPAA, because that's going to really give you some flexibility that you otherwise wouldn't have. As I mentioned, the effective dates are varying for these bills. Indiana right now is the latest at January 1 of 2026. So far, we're not seeing private rights of action in any of the bills that have passed, which is nice. You know, that's something we've talked about a lot in webinars we've done, that private rights of action create risk, especially for legal frameworks that are so gray often in their implementation. And so it's nice to see the legislatures understanding that risk and delegating the enforcement responsibility to the state rather than to private litigants. And a number of these bills have right to cure periods. Now, those vary in their length. Some are 30 days, some are 60 days. Some of them have sunsets, so they're only available for a certain period of time after the bill comes into effect. So they're kind of all over the place in their scope, but the cure periods are nice in case you do have a violation, probably unintentional. You did your best, but maybe missed something. That the state has to give you notice of that violation and an opportunity to fix it before they can pursue regulatory enforcement action. So I never hang on those right to cure periods in the sense of using those as my get out of jail free card, but they are nice to have as a backup. So it's been a busy year. And it's not over yet. As you saw, there's still a lot of color on that map. There are a lot of state legislatures that are in session still, and we might get another 3 or 4 before it's wrapped. But even in the states that have these bills already in place, like Colorado, there are developments happening. So Nick, fill us in on what's going on there.
Yeah, definitely will. Real quick, definitely beyond the scope of what today's webinar is about, but Josh mentioned the lack of private rights of action under these comprehensive federal or state laws. That Washington bill that he mentioned related to health data does have a private right of action. So again, depending on what industry you're in and depending on what your practices are, you'll want to make sure that you're paying attention to the more niche privacy laws as well, and making sure that you're complying with those and accounting for any risks that might go along with those. But yeah, turning to Colorado. So Colorado's law goes into effect on July 1, and it is fresh off of a final version of the privacy regulations. They had gone through a number of different iterations of this. And really the focus of what I want to talk about today is where these privacy regulations go above and beyond California, maybe some interesting clarifications, differences from California, just things that I think are relevant for many companies and that are worth discussing. So one, just jumping right into the privacy policies, this is a pretty significant impact. So the way California works and the way most privacy policies read today, you have a list of the categories of personal information that you collect and typically some examples of those. Then you list later how you use personal information generally and how you share it with third parties, et cetera. What Colorado is requiring is that your purposes of processing, so this would be your uses and the purposes for which you disclose personal information, have to be granular. So for each category of personal information, you describe how you're using it, how you're sharing it with third parties. So this is going to require a update to most companies' privacy policies. You might see a movement towards more of like a grid-like format that you've seen for companies that operate in Europe and in other jurisdictions where this level of specificity has been required for some time now. So it is a little bit of a fundamental shift of how we think about privacy policies in the US, at least for a lot of companies. The other thing is we often get asked when we update our privacy policies, does the CCPA in California require us to send an update? And it is silent on that. We've long said that any material updates should be accompanied by some type of prominent notice. Typically you see emails or notices on the website or both. Colorado specifically requires it, and it requires notice through some type of mechanism through which you communicate regularly with consumers. The other thing is in California, if you have a mobile app, it is discretionary as to whether you put a link to the privacy policy within your settings menu. It has to be on the download page. So if you go into Apple's App Store, there's what we often refer to as the nutrition label that has a bunch of information. One of the sections has a link to the privacy policy, but this will actually require it to be within the settings menu of your mobile app itself. So again, for anybody that has one of those, something to think about. The other thing that's interesting is we've seen a lot of websites with the link in your footer that says, do not sell my personal information. And some have transitioned to do not sell or share my personal information based on California. Colorado requires a similar type of link. They have a little bit more flexibility in what the verbiage is, but one of the options that they give you is your privacy choices. And that is also expressly authorized in California if you have the language and the California icon that goes with it, which is just available via download on the website in California. So a lot of our clients are really thinking about this. I think there was some hesitancy at first to go your privacy choices route because of the icon, but it's becoming more and more prevalent, and we're seeing more and more companies adopt it. I think it's a good idea to foster compliance with both California and Colorado now. So something to think about there. It's also a little bit cleaner. It's not, very long and clunky. So definitely an option. One of the things that's unique to these non-California states like Virginia, like Colorado, is that you have to have consent to collect sensitive personal information. And we'll get into what consent looks like in Colorado because they have a lot of specific requirements. But one of the things that I found very interesting coming out of the final regulations related to precise geolocation data. So precise geolocation data in certain states like Virginia is considered sensitive PI. It was not listed in the statute in Colorado. And when they started drafting regulations, they started focusing on things like any type of situation where you might be able to infer sensitive information, such as religion, based on where the person is located, right? If they go to a specific house of worship, you might be able to infer their religion. If they go to a certain type of health clinic, you might be able to infer a medical condition, those types of things. In the final regulations, they made an important change, which is these types of sensitive data inferences make precise geolocation itself sensitive only if you're using it in that manner. So the ability that you could theoretically kind of tie these things together and come up with those inferences isn't enough. It's only if you're using it in that manner. So I think we've got a pretty good argument that most businesses that collect precise geolocation in Colorado, of Colorado residents, are not collecting sensitive PI and are technically outside the scope of their consent requirements. But before you just completely dismiss them, remember, Virginia requires consent for that data. It defines consent in the statute essentially identically to what Colorado does. So when Colorado describes, here are all the things that you have to do to meet our statutory definition, while not binding on Virginia, it's kind of instructive as to what Virginia's regulators might also be thinking. And all of this is really pulled from GDPR in Europe. So you can go back there to look at their consent definition as well. So big takeaway here, I would encourage anybody that's collecting precise geo through a mobile app or otherwise to really think about the consent requirements in Colorado and to the extent that you can fully comply with those. Another issue that always came up under CCPA, it seemed like, is I've got a deletion request. I honored it. Am I allowed to collect that person's information again in the future. And there was not an explicit prohibition against doing that. We've always kind of said that that's not really what the intent of and the spirit of the law was. If they want to voluntarily provide it to you, great, but deleting it and then just purchasing it back from a data broker thereafter really didn't seem like that would be something that the regulatory agencies would be okay with. And Colorado just makes that very explicit, that you have to have a process to prevent the recollection of data from that about that individual. So you might have some type of a scrub list. Here's all the consumers that have asked us to delete. You're getting feeds from a data broker, and you're able to screen out those individuals who had asked you to delete their information. That would obviously require the retention of a very limited amount of data, just enough to comply with that requirement, but otherwise to not collect any information about them. Not going to get into a ton about loyalty programs. Just know that there's rules around these. There's disclosures that go beyond California. There's certain rules about when you can and can't withhold benefits of the loyalty program based on the provision of certain types of information, based on obtaining consent to collect sensitive personal information, those types of things. So if you have a loyalty program, you just want to make sure that you're not only complying with California law, but you're complying with Colorado law as well. So now kind of diving into the consent requirements. For those of you that are familiar with GDPR, a lot of this is going to look familiar. So they have several pages of what they think is required to get consent, when consent is required. I think the most obvious one I mentioned is when you're collecting sensitive PI. If you are trying to use previously collected information for new purposes, and those new purposes were not previously disclosed, and they're not compatible with those purposes, you're required to get consent. If you have an opt-out of like sales or targeted advertising or profiling, and you're trying to get consent to opt them back in, that's another situation. But I think most of what we're talking about are new uses, and sensitive PI are the two biggest ones. So it has to be clear affirmative action. You can't use a pre-checked box, and generally speaking, you can't require somebody to just consent to a large privacy policy or a large terms and conditions and deem that to be consent. It has to be specific affirmative action related to this consent. We'll get to the specificity here as well in a little bit more detail, but I think a lot of people just assume they'll just have somebody check a box and say, yes, I agree to your terms and your privacy policy, and they'll be done. That's not enough under the Colorado regulations. It has to be freely given and revocable, and it has to be revocable through the same means through which they're providing consent. So you can't require them to go down some alternative path to revoke consent. If they provide it online, they should be able to revoke it online. If they provide it through a mobile app or through some other device, they should be able to revoke it in the same manner. Specific, basically, you can't lump a bunch of unrelated purposes together and ask somebody to consent to those. They have to be granular. So the regs speak to either a single purpose of processing. I want to sell your personal information, for example, or after they've opted out, or I want to collect your precise geolocation or any other type of sensitive personal information. Or you can do consent for multiple purposes, but only if they are reasonably related and not reasonably necessary or compatible with each other. So again, you can't just throw the book there, have somebody get consent. One of the examples that they give is getting consent to collect ethnicity, race, and other types of demographic information that qualifies as sensitive, and also getting consent to sell their information after they've already opted out, and doing those two things at the same time would be impermissible under the regulations. And then last, informed, there are specific disclosures that have to be in your request for consent. So the identity of who consent is being provided to, that makes sense. The purposes for which you're seeking consent, that also makes sense. But it goes a little bit deeper than that. The categories of PI that are subject to the consent, the names of each third party to whom you would provide sensitive personal information, if applicable, and the fact that they have the right to withdraw consent. So these are high level overviews. There's a little bit more specificity even than this in the regulations. I would just encourage anybody that is collecting sensitive personal information. Again, I would lump geolocation in that, even if it's not always considered sensitive, you really want to make sure you're drafting your consents in a informed manner, in a way that is going to meet these Colorado requirements. And again, these are things that I think Virginia and other states would expect as well, even if they don't have this level of specificity just yet. So transitioning a little bit, one of the other things that Colorado law requires is a data protection assessment. So if you're selling personal information, if you're processing sensitive PI, or if you conduct targeted advertising or profiling, which creates some type of high risk of harm to consumer, and I'm kind of paraphrasing here a little bit, but those are the activities that trigger a requirement to conduct this data protection assessment. They're very similar to the privacy impact assessments in Europe, and the regulations go through a bunch of requirements as to, what type of activities you're supposed to engage in, what you're supposed to document within the actual written assessment itself. And by and large, it's a balancing test. Here are the risks that we've identified. Here are the things that we either considered or actually did to mitigate those risks. And here's why we think the benefits, either to us as the business or to the consumer or both, outweigh the risks after we've taken the mitigation steps. So anybody engaged in these types of activities, you should be thinking about this. You're supposed to do this before conducting the activities that trigger the assessment. This only applies to activities starting on July 1st. So again, we're coming up on that date now, but you'll have, I guess, 2.5 months or so to think about these types of data protection assessments before continuing or starting these types of activities moving forward. And then you're required to keep the processing activity or the data protection assessment for 3 years after stopping the processing activity. So if you're conducting targeted advertising and you keep doing that for 5-10 years, you'll want to keep these annual data protection assessments for the length of time that you do that, and then another 3 years after that. One thing to mention is that is currently required in Colorado, sorry, in Virginia. Their law went into effect January 1. So again, Virginia doesn't have regulations like this. Colorado and California have these very specific granular regulations. Virginia does not, but it still has the statute, and the statute does require a data protection assessment in similar situations. California is a little bit different. Josh is going to talk about California here in a little bit, but we're going to find out about California here through a second round of rulemaking. The last issue I just want to talk about real quickly in Colorado is this concept of profiling. So again, this is found in other state laws as well, and the regulations drill down onto what types of activities trigger certain requirements. So the base definition is quite broad, and it's listed here on the slide. I'm not going to go through all of it, but it's basically some type of automated processing of personal information. And you're using that to kind of evaluate, predict aspects about an individual person. And it could relate to their economic situation or health preferences, et cetera. But the idea is it's all an automated processing that kind of spits something out. The specific requirements, though, are dependent on what type of profiling you're doing. So the disclosures and the opt-out rights apply if you are profiling in a way that results in legal or similarly significant effects on an individual. So again, you're determining their eligibility for a certain type of product or service. You are charging them a higher rate because of some type of automated processing. If those things happen, there are certain disclosure requirements, certain transparency requirements related to the the algorithms used to create the end products, and the ability to opt out of that. If you're using profiling for, say, targeted advertising, but not for these other types of things, then the opt-out requirements don't apply. There's a separate opt-out requirement for targeted advertising specifically, but some of these other rules around disclosures, et cetera, aren't applicable. The other thing I mentioned, that if you are conducting profiling that has a high risk of harm, there is the requirement to address that within your data protection assessment itself. And again, there's certain types of risks that they outline, things like there might be a risk of an unfair, deceptive treatment of an individual or some type of disparate impact for an individual based on this profiling. There's the risk of financial or economic harm, physical harm, reputational harm. So there's a bunch of things that they outlined. So again, I think profiling, a lot of people are confused. I think this provides a little bit more light. I wouldn't say it's perfect, but I think it gives us some level of comfort that not every automated processing of personal information triggers all of these rules. They're really focused on specific types of profiling that have significant impacts or create significant risks for consumers. And so one thing we didn't talk about with Colorado, again, these are just kind of high level issues. There's a lot more than that. One thing that we didn't talk about is that it has a requirement to accept and honor universal opt-out signals like California. So, opting out of sales through some type of user-enabled privacy preference signal. That doesn't go in effect in Colorado until July 1st of 2024. And there will be a public list of the permissible signals for consumers to use and ones that businesses must be prepared to accept and process. And I think that that's a nice segue to Josh, who is going to talk about some of the issues in California, one of which relates to these types of signals.
Yeah. Before we get to that, though, we did have a question come in about whether the Colorado bill provides model forms for consent, and they do not. So, you kind of have to work your way through it based on what's in the regulations. And I think also if you look at European style consents under GDPR, that can give you a sense of how those consents may look once they're drafted. So as Nick mentioned, this issue of universal opt-outs or global privacy control is something that we're seeing under CCPA, CPRA as one of the toughest issues for businesses to deal with. So if you recall under CPRA, and CCPA, you're supposed to recognize these universal opt-out signals for do not sell and share personal information. And the one that they have essentially endorsed is called global privacy control, which is a technical standard. You can find it online at globalprivacycontrol.org. But at a high level, what it does is it allows the user to turn on a signal in their browser that will broadcast to websites they visit that they don't want their information sold or shared. And then as the website operator, you need to be able to recognize that signal and act appropriately. And as we've been working with clients to implement this and get it in place, we're seeing some common struggles that they're having from a technical perspective. The first is the inability to take that GPC signal and communicate it to your primary systems as a full opt-out. So what the CPRA regulations say is if a user comes to your website and they're broadcasting the GPC signal and you're able to recognize that user, then you need to take that signal in and treat it as a full do not sell or share request. As opposed to if you can't identify them, then you just treat it as a do not sell or share request for any information that you're collecting during that session that they're on your website or using your app, which typically means turning off cookies, right? That's frankly what it most often means, is deactivating cookies or pixels or tags or SDKs that potentially are sale or sharing scenarios. So what we're finding is a lot of clients, they can do that latter part. They can see the GPC signal and they can turn off those cookies. But they struggle with how to bring that into their main systems. And part of that is because of recognizing the user. So if the user is in a logged in state, so say I'm just going to say Amazon, like say you go to Amazon and you're logged in, right? Then Amazon knows for sure that's you because you're logged in. So if Amazon got a GPC signal while you're in that state, while you're logged in theory, they should be taking that in and treating it as a full do not sell. But a lot of our clients don't require people to log in all the time. And so that poses a challenge. Another one of the struggles is sort of how to run this in reverse. So if a consumer makes a do not sell or share request using the online form, or say they call in, because remember under CPRA, you're supposed to provide a toll-free number that they can call, and they make that request, how do you make sure then when they come to your website later that those cookies aren't running, right? That those third-party tools have been deactivated. And this kind of goes back to the logged in state situation. If they're logged in, then maybe you can do that. Maybe you have a way that the systems can work, but that's tough. And I think businesses are really struggling with that right now. Another one of the inabilities we're seeing is the ability to honor those opt-outs across devices and time. So if I come to the website from my desktop and I'm broadcasting the GPC, the website takes in the GPC and it deactivates the cookies. But let's say then I go and I visit the website from my phone. Well, in theory, I've already made a do not sell or share request when I visited that website on desktop. Now I'm visiting it on mobile. That should continue to be there. But what we're hearing from a lot of our clients is technologically, there's just no way to do that, except potentially in a logged in state. And so if you don't require people to log in, then you can't really flow that through. So what we're seeing emerging as some strategies to deal with this, and I don't know that any of them are really 100% compliant, but they seem to be good faith efforts to deal with the technical limitations of the online environment, is sometimes this two-step process. So the consumer goes and they make their do not sell request using the online form, and then the online form explains to them, in order for you to essentially fully make this request, you need to go over here to the cookie tool and turn off cookies. Oh, and by the way, you got to do that step on every device that you use. And potentially every time you visit the website, right? I don't think that fully gets you there, but it does seem to be at least a good faith way to deal with these technical limitations. And go ahead, Nick.
Well, once you're done with that, we have a question I thought it might be a good time to answer, but I'll let you finish any other preference signal cookie type of issues that you want to get through.
Well, the other thing I was going to say is this is an area where we've already had a company fined, right? Sephora paid a $1.2 million fine for not having compliant opt-out practices. And so this is an area where we suspect the California agency is going to focus. And so businesses really need to pay attention to it.
Yeah, and I'd piggyback on that. We're talking about enforcement here in a little bit, but just remember that the CCPA's right to cure period is no longer active. So previously they had to give you 30 days to cure. Sephora got hit with a fine, presumably because they didn't fix it within that 30-day window. But that right to cure period has expired, and now it's up to their discretion as to whether they want to give you some time period to cure or whether they want to just initiate an enforcement proceeding.
Yeah.
Real quick, Josh, turning to a question. We had a question about the update for the Chamber of Commerce lawsuit requesting that we push back the implementation date of CPRA.
Yeah. So for those of you who may not have heard, the California Chamber of Commerce sued the California Privacy Protection Agency, essentially saying that these regulations were so delayed that the CPPA violated the requirement under law. In fact, some of the areas they were supposed to regulate, they still haven't. There's a second rulemaking, Nick's kind of mentioned this, with topics around profiling, data protection assessments, and high-risk processing that is just starting. And so they don't we don't even have much there on that rulemaking. But even with this set of rulemaking, they didn't get final until a couple weeks ago, and they have a January or July 1 enforcement date. So the chamber is asking a court to order the agency to finish the rulemaking and to delay enforcement of those rules until 1 year after the rules are finalized. All of them, all the rules. So it'll be interesting to see what happens there. I think they have a good point. Their point is, if you look at the ballot initiative, these rules were supposed to have been finished July 1st of last year so that businesses would have a year. And that should be the expectation. Unfortunately, the last time I looked at the docket, the hearing on this wasn't until June 30th. So unless that has changed in the last couple days, that means that there wouldn't even be a hearing until the day before the rules are set to be enforced. So my recommendation is to continue to push ahead as if those are going to come into force on July 1st. And the CPPA has stated that they will take the fact that these were delayed into account in enforcement. And so if there is an issue there, I would push back on the agency and say, look, you essentially gave us 3 months to do this. We need more time.
Yeah, I think
but it'll be interesting to see what happens.
The lack of a private right of action there, I think, is very important to that. I think, although regulatory agencies don't always proceed in a way that we might think is practical, I think the likelihood of having a meaningful dialogue with a regulator is much better than one with a class action plaintiff's attorney. So, Hey, Josh, I know you have to run a little bit early. Do you want to maybe get through your other CCPA slide and then I can finish the rest?
Yeah, so just to wrap here on this point, and then I'll leave you in Nick's capable hands. And if any of you are joining the Lead Gen World podcast at the top of the hour, you'll see me there. But one of the other main issues we're seeing has to do with service provider and third-party contracts. So the CPRA regulations were very explicit in what needs to be in those contracts for both service providers and third parties. And there are specific terms for each. That means that businesses really do have to figure out each vendor, what bucket they sit in. And sometimes they fit in both buckets, right? They may be a service provider in certain respects and a third party in others. What this means is, once you go through and you categorize all of those vendors who are processing personal information or selling you personal information, or to whom you sell personal information or you share personal information with, then you have to renegotiate. And you have to get these contract terms built in. And we have clients who have hundreds or thousands of vendors, and they're working to make these changes happen before July 1st. And it's tough. But the first step, and this is the one that we find a lot of our clients are missing, is really an analysis of, these are all of our vendors and here's what they do, so they fit within either service provider or third party or both. And really sitting down and making that master list is key. Without it, you can't even really make progress on this.
Yeah. One interesting thing there is service provider contracts and the requirements for what provisions need to go in them. That's been around for a while. It's a moving target in terms of the actual substance, but that concept has been around under other privacy laws. It was required under CCPA. So it's really just advancing the ball a little bit. You may be substantially compliant, even if you don't have, the next wave of CPRA, Virginia type of provisions in there. But the third party one that you're talking about here, Josh, that's a new concept. These privacy laws generally didn't regulate how one business that sells personal information to another business, what that contract needs to look like. And so these types of third party contracts, this is a new issue and something that there's probably not a whole lot in place in terms of those contracts addressing very specific privacy issues, other than maybe comply with all laws type of provision. Yeah. So I definitely think it's something that a lot of companies are probably not familiar with and really struggling to come to terms with and and fully get into compliance with.
Yeah.
Okay. Well, Josh, I know you have to run. Thanks so much. I'll go ahead and wrap up. And there's a couple of questions here. I'm gonna save those to the end. I have a real quick enforcement update. Then we can get into some questions. Happy to answer other questions that come in between now and the end. So, this is often what we get asked the most is, what's going on in terms of enforcement. The one fairly nice thing about California is they have a website that lists anonymous enforcement actions that they've taken. Unfortunately, they have not updated it since August of last year. So there's not a whole lot of new information to glean. Just as a recap, the things that they had taken issue with and reached out to companies and asked them to cure in the past were mostly public facing issues. So privacy policies, your notice at collection. So this is the requirement to provide certain notices before you collect personal information. Or just referring them to the main privacy policy is generally not enough for this, by the way. The opt-out links that you have in your website footers, the ability of your site to accept these privacy preference signals, those types of things. And then also things where maybe there were some complaints related to the fulfillment of a privacy request or your ability to do intake and then honor those requests. So you can go through the website, you can look at the types of things that they focused on. I think it's pretty enlightening. You'll see the industries are very scattered. It's all across the board. The issues are pretty broad, but it highlights the importance of anything that's public facing and anything that's likely to result in some type of consumer complaint. Those are the ones that you probably should focus on first, and then work your way down maybe to the lower priority items. Importantly, though, and I mentioned this earlier, the right to cure in California has expired as of January 1st. So there is an increased risk in California that they just reach out and say, at least with respect to the CCPA issues, that you're not in compliance and we're going to fine you or we're going to initiate an investigation. CPRA becomes enforceable on July 1st. So we've got a little bit of time here. I think the priorities there probably will look a lot like what you see here for CCPA. And then they'll probably add some additional things related to concepts like data minimization. So really not collecting and using information in ways that a reasonable consumer would not expect. There's this concept of data minimization, both in terms of collection and use of data, that I think will be important for them. The other really big one, I think, is dark patterns. You'll hear this buzzword or phrase thrown around a lot. And essentially the concept is, it's intentionally designing a website or some other type of user experience that has the effect of impairing their choice or autonomy or decision-making. So it's ways to get them to click the accept button rather than exercise meaningful choice about what you're collecting from them. They actually are using this term dark patterns with respect to everything from, hiding ways to cancel automatically renewing contracts online and a bunch of other things that aren't specifically privacy related, but it's used most often in connection with privacy laws and collecting data and getting consents and things like that. The other state privacy laws that we've mentioned, again, Virginia is enforceable today. We haven't really seen much public enforcement yet. Colorado will be coming here shortly, and then all these other states that Josh mentioned will be coming online as well. So I think it remains to be seen in terms of who's most active, what issues are they really getting into, but I would anticipate this to really mirror what you see in other consumer protection areas, which is anything that they think is high risk to consumers, anything that results in potential harms, anything that generates a lot of complaints, and anything that just right on its face just is blatantly non-compliant. Those are the items that I would expect to be at the top of the list for the regulators. The other thing, and Josh and I did a webinar last year. It's probably, I think it's still on our website for those that want to check it out, but it related to enforcement of some of these legacy privacy laws and general consumer protection laws. So because these newer emerging state laws do not have private rights of action, with the exception exception of CCPA and CPRA, have a very limited private right of action for data breaches and data breaches of very specific types of information. But generally speaking, they don't. So the plaintiff's bar has been focusing on these older laws and trying to apply them in new ways. We don't really have time to get into the weeds here, but the things that we've seen lead to to private lawsuits are data breaches. That should come as no surprise to anyone. I think most of you have probably heard about all the biometric identifier lawsuits in Illinois primarily. You've probably caught wind of some of these wiretapping lawsuits in California, Florida, Pennsylvania, a few other states. And what they're alleging there are certain tools. So a session replay tool on your website that tracks movements or keyloggers, those types of things are violating the wiretapping laws in these states. That then transitioned to website chat tools. So kind of recording those conversations without some type of notice or consent. And the most recent one, this is the one I want to highlight because this one is a little bit different than what we had talked about in that last webinar, is just the mere fact that you have a Facebook pixel on your website. And the argument there, and this has largely been one firm that's driving the action here, and they're sending arbitration demands and mass arbitration demands to companies. But essentially their arguments are kind of twofold. Number one, that these third parties like Facebook, they are capturing the contents of a communication between the website user and the website operator. So that's a communication in their minds, and the pixel is capturing the contents of that communication, what's going back and forth. And then secondly, that the website operator is liable for allowing that to happen. California has like an assisting and facilitating provision. Not all laws do, but the kind of general argument here is that the website operator can be held liable. Strength of that argument, I think, probably depends on the specific law, specific state that we're talking about here. So a lot of these are still working their way through the courts. With respect to the pixel issue, again, it's arbitration. So it's not like you even have a court opinion that's addressing the applicability in this context, at least not yet. But really the takeaway here is that all of these types of things are really ripe for novel arguments. I think some of the arguments are weak. Some of them maybe have a little bit more merit. Really need to be thinking about your websites and what integrations you have and what you can do to mitigate risk. How can you get consent? And how can you get consent before these tools are activated? So before Facebook gets the data, for example, before the session replay technologies are in use on the site. The Video Privacy Protection Act largely relates to websites that have videos and also have a Facebook pixel. So Facebook is understanding what videos each user is watching and can glean certain inferences from that. Something to think about there. And then the general consumer protection laws generally stem from, we don't have a private right of action for a privacy law, but we think your privacy policy is deceptive. It said you wouldn't do this and you did it. It said that you would do this, but you did not. So basically deceptive statements, or the argument that a certain practice is unfair. And so we're going to pursue under our general consumer protection law. None of that is new. That's just an evolving thing. That's generally what almost all plaintiffs firms use when they don't have a specific law to point to. So with that, we do have a bunch of questions. I'm going to take as much as I can. And then if I don't get to it, feel free to follow up with Josh or I offline, and we're happy to jump in as well. First question asks whether a telephone number in isolation is considered PII, sensitive personal information, or otherwise protected by the new laws. I would say it's definitely personal information. You can reasonably connect a phone number to a person, generally speaking. And it is not sensitive personal information, though, as defined under most of these laws. So to the extent that you have to treat it like personal information, things like disclosures, that type of thing, yes. To the extent that you have to get consent for sensitive PI and those types of things, then no. Second question relates to cookies and essentially what happens if the website won't operate fully without the cookies. Well, we're talking about things like opting out of cookies, and Josh kind of talked about that as how you effectuate a do not sell or do not share request. What he's really talking about are the types of, and we use cookie kind of broadly here, it's really referring to any type of, ad tracker, tag, pixel, etc. But it's generally the third party ones that would result in a sale or a sharing. So obviously the ad trackers used for targeted advertising, those qualify. A analytics cookie could qualify depending on what type of contract restrictions you have in place with that third party. If they're allowed to use the data for anything that they want, then that's going to be deemed a sale or sharing. If the contract says that they can use it only on your behalf as the website user or the website operator, then that would be something that we could treat more like a service provider relationship and not a sale to a third party. But most of those cookie tools, they'll have the different categories of cookies, and one of them will be essential. And those essential ones generally don't provide an opt-out. The one caveat there is a lot of people think something is essential when it's really not. Like, it's a nice to have and it's really important. The business really wants it, but it's not like the website cannot operate without it or becomes unsafe without it. So I'll just challenge you to think about what really is and is not essential. Does a blanket amendment work for vendors? I think this relates to the contract issue. Sort of. So we often use template contracts, data protection or data processing agreements, or DPAs, or something that we often use. Those can be largely standardized. So if you're a service provider, you're going to agree to this DPA. This DPA has all of this language that's mandatory. The one caveat to that is that some of these newer requirements in Virginia and under the CPRA have a certain amount that needs to be specific. So the type of information that's going to be processed, how it's going to be used, the specific purposes. And so oftentimes what we do with our DPAs is you've got the main sections, and then you've got some type of an appendix at the back, and it's kind of a fill in the blank. It's got all of the bones there, and then you just have to fill in some limited information. So some customization may be required if you want to be fully compliant. Somebody asked about sharing slides. Happy to do that. We always post these webinars on our website as well. So that will be available. The map, ask about the state map as well. That is an IEPP publicly available map. So if you just Google IEPP state privacy laws, you'll be able to see their website and follow along with some of these new privacy developments. Last question here, and then I'm gonna wrap, but I'll be happy to answer any others offline. For CPA and the requirement for data protection assessments, if you're presently engaged in target advertising and don't materially change that, would an assessment be required by July 1st of 2023? Would it only be required when the process is substantially changed? So the answer is, as long as you are still engaged in an activity after July 1st, it might trigger the data protection assessment. But I will just mention that targeted advertising does not always trigger a data protection assessment. It's only targeted advertising that creates a material risk of harm to consumers. And it's not a black and white line, but the easiest way I can explain it would be if you are tracking people and presenting advertisements that relate to specific medical conditions based on the types of searches that they've done online or those types of things, that is much more likely to result in harm than tracking somebody that's looking for some type of article of clothing or for windows for their house or for something like that. So I think the type of industry that you're in and the products or services that you might target and how you are targeting them, what types of factors you're using to target would weigh into that. So just understand that not all targeted advertising requires a data protection assessment. All right, so I know we're a little bit over time. I appreciate everybody jumping on today. To the extent I didn't get to your question, a lot of these are anonymous. Please feel free to reach out to Josh or I. Our contact information is on the screen, and we look forward to hosting another webinar here soon. So thanks for attending, and we appreciate it.